Welcome to today's program titled Virtual I-9 and Other COVID-19 Compliance Concerns. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. This session is being recorded. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Leon Rodriguez. Leon, please go ahead.
Good afternoon. It's a pleasure to be with everybody this afternoon. Today we're going to continue talking about the I-9 verification process in the context of the coronavirus pandemic. I think as most of our listeners today know, back in March, Immigration and Customs Enforcement made an announcement allowing for some flexibility in the manner in which Forms I-9 need to be prepared in the event of a new employee joining your business. As with all things involving the government, with flexibility often comes complications, tricky questions. So while this flexibility permitted in certain circumstances for remote I-9 verifications, there were several restrictions and procedures required, and also, in a big topic of our conversation today, some specific requirements about what needs to happen when, in fact, the world starts reopening and employees start coming back to the physical workplace. Today, I'm going to be joined by two of my partners, Dawn Lurie and Angelo Paparelli. All three of us are co-chairs of Seyfarth's Immigration Compliance and Enforcement team, part of the Business Immigration Group at Seyfarth. Angelo is considered one of the deans of the National Immigration Bar. He's one of the founders of the Association of Business Immigration Lawyers. And Dawn Lurie is considered over decades now one of the real experts nationally in immigration compliance and employment verification. So we really are lucky to have this exceptional panel this afternoon. So without further ado, I'm going to turn it over to Dawn for an overview of where we are and where we're going.
Excellent. Thank you. All right, Kelly, we can go on to the next slide. Thank you. So for everyone on the call today, I'm fairly certain that you're familiar with the I-9 requirements. Pre-COVID, we had a fairly vanilla process. Individuals had to complete their Form I-9 employment eligibility form by the third day of employment. Section 1 had to be completed on or before the first day, actually. Individuals had to present unexpired original documents. Employers had to view them. There was a physical inspection requirement, and the USCIS deemed that to be an in-person requirement. Employees could choose which documents, and again, this had to be done by the third day. Section 3 had to be completed if somebody had a work authorization that was expiring. Next slide. Okay, then COVID hit, right? We're mid-March. Everything is a little bit crazy. I-9s, admittedly, are not first thing on anyone's mind, but there are large employers that are ramping up and are starting to hire a large number of individuals in certain sectors, right? It depended upon what it was that you were doing. Some employers just continued to hire. and some of them were hiring very large numbers. So we went to ICE, we went to USCIS, and we basically said we need a solution. We cannot have individuals completing I-9s in person. We understand that that's your interpretation of the regulations, but we need something. We'd like to be able to do virtual. So we received, in mid-March, March 20th, we received a directive from ICE that basically said, okay, we're going to allow you to conduct your I-9s virtually under certain circumstances. Next slide. So the problem with what we actually got was ICE's guidance. Basically, they said that you can complete your I-9s virtually if you are remote, if you're operating remotely. Since the initial guidance that had gone out in March, ICE, HSI, Homeland Security Investigations, has twice extended the remote guidance, the ability to conduct the I-9 reviews virtually. And the last time, in the most recent June guidance, they basically, they changed the language a little bit, and they said DHS has decided once again to extend this policy for employers operating 100% remotely in light of COVID-19 for an additional 30 days. So we're now out through July 18th. The fact of the matter is that right from the start, certain businesses were not able to use the virtual I-9 completion, and many large companies went to authorized representatives. We'll talk a little bit about the friends and family method. Obviously, you couldn't really go to a third party if you were sheltering in place with your friends and family. But basically, the documents had to be reviewed, and also employers had to keep still have to keep a written policy of their teleworking or how they're allowing individuals to return to work from home. Next slide. And Angela, I know we've spoken many times about that 100% requirement. And I'm not talking about in the context of returning to work, just in the ability to use the virtual. Do you think that there's any ability, if you have, anybody on your site, like maybe a security guard, for example, do you think that ICE intended to remove the ability to use the virtual? Can't hear you, Angela.
Thank you, Dawn. I'm sorry, I was on mute. I'm happy to be here. Also, I wanted to note one omission from Leon's excellent introduction, and that is that he was the former director of USCIS and a former assistant U.S. attorney, so he brings a wealth of experience to this panel. In answer to your question, I think it's important to recognize that ICE, in its announcement, did indicate that they would exercise discretion, enforcement discretion, in some limited circumstances where it might not be 100% remote. And so employers are going to need, as we will discuss, to document what those unusual circumstances might be. But as you suggested, a skeleton crew or just a security guard, let's say, no skeleton crew, just someone watching the building, would, in the employ of the employer, would not necessarily, in every instance, defeat the notion that virtual I-9 completion can be nevertheless accomplished.
And I agree. I think ICE, they obviously, the guidance that Homeland Security Investigations has provided was in conjunction with their leadership. My understanding is that it even had been reviewed by the White House. So we know they're going to be tough on that. And the fact that, I think this is a big one. We don't have HR on site. We have teams, but we don't have HR. I think we can pretty much count on the fact that ICE doesn't care. If you don't have HR, you need to find another alternative. And we've gone back and forth with them on that. So at that point, you may need to consider the authorized representative or having somebody else take a look at those I-9s. One of the things that I want to remind people is having that remote work policy in place, making sure that it is documented, that you are remote. So we have individuals taking, emails from their CEOs, emails from HR managers, and then kind of putting them into a binder and, documenting what this what this work from home policy was. So it is going to be important that, as we go forward, we continue to maintain this. And, there'll be strategies that we'll be talking about over the course of the next few months. Okay,
and I might mention, Dawn, as we're switching slides, that this idea of putting things in a binder is often confusing to those who use the electronic I-9 system of signature and storage, because there are no real binders. There are often limitations based on the software itself that restricts how you attach one record to another record. And so you may have a parallel universe of paper binder and miscellaneous electronic records to put together at the end of the day.
Excellent. We're going to talk about the good, the bad, and the ugly of electronic I-9s, and I think that, we are going to see who the winners and losers are in these systems, those that were able to pivot and be able to provide not only, the bare bones, but actually to provide their customers with usability features to make things easier. And so, yes, certain systems you'll be able to upload things and keep them in places, and then others you're going to have this bifurcated, ridiculous, partial hybrid system where you have some stuff in paper and some stuff electronically. So, hoping not. All right, we're going to go to the next slide. So, again, the core guidance that HSI gave out was allowing Section 2 documents to be reviewed remotely. They referenced the video link, the fax, the email. I'm never going to let those over at ICE that I chat with, let go on this whole fax thing. Seriously, who has a fax? I want to remind them that there's things. I mean, it's just, the fact that we're talking about a fax is just indicative of where ICE was when they issued this guidance. But I don't want to, look a gift horse in the mouth, because I appreciate the fact that they gave us anything. They really didn't have to provide anything, at least, not that early in March. So, we are thankful that we have some sort of, ability. For some companies it worked out. So I think the big caveat here is that it's a lot of work, right? And so for those of you that went with the virtual, now that we're returning to work, there's a lot of work. It's a double touch, right? So if you did the I-9s virtually, now you're going to redo them all again. And I think the core thing for everybody to remember is that ICE is really, from what I understand, things could change because leadership changes and, focus changes, but from what I understand, the focus is going to be what happens when you return to work. What did you do? So even if you messed things up and you didn't get your 3 days with the virtual and you didn't complete it correctly, or your electronic I-9 had a problem, when your people come back to work, that's when they're going to be looking at things. In addition, and we're going to talk about if your people never come back to work, did you put together an authorized representative policy, and did you do that correctly? So I think that's going to be like the focus for the government. If you are using virtual, please remember you absolutely have to have your documents. I spoke with 2 companies last week that mentioned that their electronic I-9, speaking of electronic I-9, Angelo, that their system wasn't able to allow those in the field to update or to upload documents, and that it really wasn't that much of an issue previously because only some of their sites were E-Verify. For the other company, they were doing E-Verify centrally, so for whatever reason, it wasn't a big issue. It is a big issue. When those I-9s documents are copied, they become part and parcel of the I-9. They're attached pursuant to the regulations. So when you take those documents, you want to have them uploaded and you want to have them attached. If you're using electronic, if they're paper, don't put them in a personnel file. If you are working from home, don't put them in your desk drawer. put them with the with the actual I-9. All right, next slide. Next slide. We're going to talk about some of the guidance that we have. So we had a lot of questions. It was 1,001 questions. I think everybody over at the agency was, they were like, oh my goodness, another email from John at Seyfarth. What about this? What about this? And I think, it got to the point where somebody at, I heard this twice, somebody over at ICE said, do your clients really think, are you making this up, or are companies really asking these questions? And I heard that twice from two different people. But I assure you, you all are asking these questions, and these are all excellent questions. And we hope to, kind of go through them today. And I see a lot of the queries coming in on the remote. So Angela, and Leon, let's stop really quickly before we go on to the nuanced Q&As. I mean, they're talking, some of the questions that we're getting is some of the associates are required to be on site, because you have a call center or production center or fulfillment center, then remote completion doesn't apply. I believe that to be correct. If you have associates on site, even if you don't have your HR, I do think that that's not who the I-9s were intended. That's not who the virtual was intended. And the same thing for the essential operations. I think if you have a group of essential operations, you can either use authorized representative, or you can have somebody within that essential operations group conduct the I-9s. Angela, Leon, anything else on that?
Well, what really is the problem is it begs the question: what are normal operations in a post-pandemic world? And unfortunately, ICE has not provided an answer to that, and we'll get into it in more detail. But in the absence of that, employers are going to have to use their reasonable best judgment.
Yeah, and I think with the questions that are coming in, these are just initial, not even return to work. I think I'm dealing with the questions of just, people that are continuing to use the virtual. And by the way, the virtual right now can be used up until July 18th. That does not mean that on July 18th, you're going to have to do all your I-9s within 3 days of July 18th. We're going to talk about when you're returning to work. That just means that you can only use the virtual until July 18th. Whether or not it will be extended, we're not sure. We do know, and I'm going to mention this now, we do know that there has been a moratorium on any movement on individual companies that were served with notices of inspection, basically I-9 audits. The government had said if you were served in early March, because, incredibly, they were still serving NOIs in early March, that you did not have to respond to your NOI. I will say we had a number of NOIs for companies that went out in early March, and just last week I started to get communications from the agents basically asking us, so, what's the status of your companies? We do need to start to respond. We want to see your responses, later on in July. So we kind of want to, take a pulse. So if you do have an open notice of inspection, you're certainly get in touch with us, because that's, there's some logistics that we may be able to help out with. And the same thing with the E-Verify cases. If you do the E-Verify case initially, you're not going to have to. You do your E-Verify case within the normal 3 days, and you're not going to have to do that again. That's a great question that somebody asked.
Yeah.
Go ahead.
Yeah, no, the one thing I'd want to add about this question of after normal operations resume, because I think there's going to be a spectrum of what businesses are going to do to try to comply with this. I think where this is going to get complicated both on the employer side, but also I think to a degree for the Department of Homeland Security, is that as we speak and for the foreseeable future, most jurisdictions can continue under some sort of encouragement to or requirement to limit the number of people in the workplace. And that's something that, given the trends that we've been seeing in recent days with respect to the growth of coronavirus spread, the growth of hospitalizations, that's going to be a factor that I think is going to end up being very difficult for ICE to get around, having given this permission. Having said that, I think there is a question of do you want to fight later on, or do you just want to be in compliance when the time comes? But I think there are going to be defenses for those businesses that find themselves really with no choice, given what their local conditions are.
And just to add to that, Leon, what's left unsaid here is that there's going to be an administrative law judge at the end of this process who will have to decide what was reasonable under the circumstances, and ICE won't be the final arbiter of what it means to resume normal operations.
That's right, and we're going to talk a little bit more about those the normal operations in a couple of slides. I want to get through some of the the basics. And I do agree. I can't wait to take some of these cases to the administrative law judge because it's it's going to be difficult. But keep in mind, again, there's always that authorized representative model, so ICE is not tying our hands. So again, we got these. We have a lot of questions, and we were not getting a lot of answers. So in terms of the specifics, USCIS, next slide. USCIS first came out even before we were talking about returning to work. They recognized that there was an issue first with E-Verify and then also with certain documents. So with E-Verify, what we were told is that they're extending the timeline. So normally, individuals have 8 days to either contact if they have what we call a tentative non-confirmation, some mismatch of their documents. They're extending the timeline for the employees that need to either contact DHS, but especially the Social Security Administration, because those offices are closed. We've seen some interesting. I had like 3 queries last week where Social Security was actually asking, in most cases, I had one where they were asking someone to send in original documents. I only had one. The other ones were all, they wanted copies of certain documents to see if they could clear the TNC. But what I'm told from the verification division at USCIS is that they will not put something into what we call a final non-confirmation if there is the inability for the employee to address the no match. So if you have something where the employee got a final non-confirmation because they didn't go or contact the office, my suggestion would be to call E-Verify. So again, USCIS addressed the E-Verify. They said we're going to be reasonable in these timelines. The other thing that became a large issue early on was the issues with the timelines for List B documents, where states were either extending or not extending a driver's license and IDs. Angela, do you want to talk a little bit about the
Sure.
here?
What has caused a great deal of confusion among employers is the distinction between what is a receipt and what is a temporary authorization. And bear in mind that some states, I know Minnesota is one, but there are many others, have issued temporary licenses that included a photo. And those temporary licenses are satisfactory as List B documents because of the inclusion of the photo. They're not a receipt for a permanent license, and so accepted once and verify in Section 2, and that's the end of the story. Unless, of course, it's a remote verification. But some are receipts, and those have to be treated under the receipt rule, but then there are special extensions that have been granted. Go ahead, Dawn.
Yeah, I was just going to say, so what Angela was talking about there was really, it's not a COVID issue. Angela's reminding people, because I think it's just getting confusing in the context of COVID. He's reminding our audience that there are some driver's licenses that are temporary. They look like maybe a receipt for a replacement, but they are actually temporary licenses, so they're not considered receipts. So there are certain states that issue that. Again, this is not a COVID thing, but for some reason it's confusing employers right now. So if you're not sure whether or not you're getting a receipt or a temporary license, this has nothing to do with the extension. You can certainly, take a look at I-9 Central or USCIS where they give clarifications. But generally, if there's a photo and a description that says temporary, then they're acceptable, even when they say on them some of those licenses are stamped, but they're not for identification purposes. That's different. But let's go back to the COVID-related issues. And so in early March, USCIS basically said, okay, if the guidance, did we lose the slides? I hope we lost the slides here. Yeah, thanks. If the USCIS basically said that the issuing authorities may have extended, if they extended their driver's licenses, for example, that they were able to be accepted, right? So basically, you had to, and you still do, you have to go on the local DMV website. You have to take a look to see whether or not a driver's license or a walking ID or basically any List B document was extended by the issuing authority. So these are documents that expired after March 1st, after COVID started. If you have one, if your employee presents one of those documents, you have to take a look and see whether or not it was extended. So if it was extended, if the issuing authority agency says it was extended, then basically you won't have to do anything else. You're just going to take the document and you're going to record it. We're going to look on the next slide. If it wasn't extended, what you're going to do is you're going to treat it like a receipt. Exactly. So thank you for the next slide. So in this case, this is a document that you can see it expired on April 29th. You're going to record the document, you're going to use it as a List B document, and then you're going to say COVID-19 extension, okay? That's what it's going to say in there, and you're done if the document was already extended. Let's go to the next slide.
And Dawn, as we're transitioning, these images have been provided recently by USCIS, and so we're not creating these for illustration purposes, but this is actually from the agency.
That's right, and we'll send out a link, and also our blog will be posted today that basically goes through some of the Q&As. I mean, we sent in, I don't even know how many questions, and we got back 6 examples. And really, we applaud USCIS. I know they were working with ICE on this to give these illustrations, because I think that's what employers were craving. What should we be recording? That said, I think that the scenarios that we have, and there's 6 scenarios that they gave in the link, I think that they were very, very basic. And we'll talk about some of the things that either we don't agree with or where you might need to be more careful. So in this one, you're entering the document here. It expired on March 5th here. You're going to put the same COVID-19, but in this case, in this example, the person is submitting a document that is not extended. There was no auto extension, so we're going to treat it like a receipt. Now, it would have been really nice. Let's go to the next slide. It would have been really nice for those of you that do I-9s to actually then do it exactly the way we would do a receipt for, let's say, a replacement document. But that's not exactly what they asked us to do. So when the employee comes in, and then they'll have 90 days, just like with a regular receipt, when they present the unexpired document, you're actually going to, you're going to redo the physical inspection, and over there, you're going to put in the new document that they put in. And I think in this case, this is so small on my screen, it's the USCIS government ID card, the new document number, the expiration, and the new date that it expired. Now, this assumes that it's the same person that's reviewing the remote and the subsequent virtual. As you'll see in some of the other examples, if it's somebody else different, In other words, Angelo did the first virtual, and now Leon, the person comes in and is presenting the actual documents. Leon should put his name. He should put Leon Rodriguez. He should put his title, not just the initials there. So they want to. Go ahead.
And Dawn, because this is a renewal of an EAD with a receipt, it forces employers to differentiate between those EADs, employment authorization documents, which upon filing are automatically extended, and those which are not, which has always been an area of confusion. But just understand this particular image is not self-explanatory.
Yeah, so no, this one is actually not the EAD. This one is just a government ID. These are List B. We're talking about List B, not A and C right here. So that's a great point, though, Angelo. We didn't get that far into this. We just don't have time to talk about all the different samples. But right now, just List B documents are being allowed to take. You're allowed to take a List B that's expired. We asked, we really asked him, what about green cards that are expired? What about passports? But unfortunately not. That's they're not allowing that. And so yes, in these cases, you absolutely can present a document that was different than what was presented during the virtual inspection. And in that case, my suggestion would be to either cross it out, whatever the new document is, or just to put a note and then put whatever it is that you're recording. And right here, this is actually a great example. You can see that possibly they got a new document and they're putting down in the additional information box what that new document is, and then they're recording it. So yes, it is absolutely possible to be able to do it that way. So
and I think it's a good opportunity to remind people that the employee gets to decide always which document to present, and the employer should not be specifying or insisting upon a particular document. Otherwise, there'd be an unfair documentary practice and a fine for immigration-related employment discrimination.
And the only time that's, speaking of receipts, the only time that doesn't hold true is in the regular receipt, a receipt for a replacement document. The guidance is that, let's say you have a receipt for for a lost Social Security card or a lost driver's license, and you're presenting a receipt document that, here I applied for a new driver's license, it's good for 90 days. At the end of 90 days, USCIS requires that you bring in the actual document that you got the receipt from. It's really a pet peeve of mine. I've brought it to the Department of Justice and have asked them to opine on it. And we haven't done anything formal, but basically it's allowable. In some cases, we've actually had to, quote unquote, term somebody and then rehire them with the new documents, which is kind of ridiculous. And I hope at some point USCIS rethinks that and would allow. So let's talk about, we're getting a lot of questions on the resumption and the new normal. So Leon, I'm going to turn it to you just to kind of, kick off. We started to talk about what it's going to look like, the fact that we recognize, and ICE recognizes there's going to be phase-ins. In our office, Leon's one of the managing partners in our DC office, and we're not going to be bringing everybody back in on September 1st. Not everybody's going to walk into the office. I know that there might be different practices coming back, different lines for different types of companies. What do you think that companies are challenged with, and how do you think we should be kind of starting this conversation with ICE? And Angela, I'll turn to you.
No, I think our office is actually a great example to start with, because we're in the District of Columbia, which has mandated a maximum occupancy for workplaces of 25%. And so that means that we're going to be in a situation where we cannot bring all employees back to the work site. We're going to have to make choices about who we bring back. And the way we've done that until now is by choosing who is essential. And while ICE has sort of respected that the process is not going to be sort of a toggle process where, one day there's a skeleton crew, and then the next day everybody's back at work. It really has given us very little guidance beyond that as to what they really consider to be a resumption of normal operations, and this is where we as lawyers and we as HR professionals, need to do our jobs, and need to make the judgment and sort of be straightforward with our clients as to the risks of various courses of action. The one thing we know is it's going to be different for everybody, and so when is your skeleton crew going to get there? When is your HR going to be back on site? And also I think a big question is going to be, a lot of us are actually getting used to working from home, and our employers are getting used to sort of managing a largely remote workforce, which means that in a lot of places for a long time, people will remain largely remote for some time to come. And so what are you going to do with those folks? Are you going to ask those folks to be coming back in?
Right, and you don't have to. I mean, I keep mentioning the authorized representative. You don't have to do that, right? There is a way to have a third party, a friend or family member. I think where we're going to run into issues is we're going to have somebody that maybe has an accommodation that is sheltering in place, living alone, right? They may be by themselves, and they're not comfortable. They have no friends and family that can do this for them, and they're not coming into the office. So, I mean, we haven't had that yet. When we have a large number of those, we'll take that back to the government, but certainly, we're going to want to document it, and, be able to just say, like, at this point, the person's still not physically in. So we do have a question about, go ahead.
I was just going to say there is, on the face of it, an apparent contradiction between the requirement that this is available to employers who are 100% remote and the resumption of normal operations. It seems to me that the agency has consistently referred to normal operations, and it will require them to define that, to flesh that out, and retreat from that apparent mandatory 100% in order to qualify for virtual compliance. The other thing I would say is that the government is really putting employers on a hot seat in the sense of giving only an alternative of authorized representative, because the authorized representative entails the assumption of liabilities of the errors of the authorized representative. And in a remote environment, it's very difficult to provide that representative with the proper level of training and the proper level of oversight and supervision to make sure that the authorized rep is complying with what are admittedly very complicated I-9 regulations.
Yeah, so even though we have a later slide, let's talk about authorized rep right now, since we keep bringing it up. And for those of you that aren't familiar with it, it's basically allowing a third party to step into your shoes as an employer to complete the I-9. You won't have to do it again. You're basically going to accept the work that somebody's done for you and completed the I-9. So if you are putting together a program like that, and many of you have these programs where you have remote workers, people that were just not coming, they were never coming into headquarters or they were working from home. I think it's important to make sure that you have clear instructions, that you have some sort of template, that you have samples, that there's a place that somebody can call if they're confused. A big thing with the authorized representative is making sure that the documents, the document copies are sent securely somewhere. So for those of you that have electronic I-9 systems, there may be ways to upload where they don't even, ever stay on your phone or stay on your computer. But safeguarding that personal identifying information is really important. And as Angela said, you're basically accepting the liability. So if the third party, whether it's somebody's spouse or their neighbor, if they say, oh, this document doesn't look good, I can't take it, it's not on the list, but really it is, technically you could, if there was some sort of broad practice that was that somebody could identify, which I think is just not really going to happen, you could have a problem with that. And then, of course, the biggest issue that, Angela and I have talked about, all of us have talked about in the context of investigations is perjury. That's it's a very big issue if somebody is taking a fake document and then attesting to it. So what's the solution here? I mean, I think the solution here is that if you're going to use an authorized rep, you basically need to count on having an audit function. Every single I-9 needs to be looked at. It needs to be looked at for accuracy, it needs to be looked at for completeness, and it has to be looked at for legitimacy, the documents themselves. So if you're going to use an authorized rep, I would mandate, if you don't have a document copy policy, I would mandate having one, just like the virtual one does. So I think it is, it is really critical to consider that.
Dawn, let's go and answer as best we can, some of those questions on this slide, especially the last two questions. What about employers who allow 100% work from home and never resume normal operations? And what about groups such as summer interns that will be 100% work from home? I could argue that in those classifications, normal operations never resume, and merely doing the stage one of virtual completion is satisfactory, rather than being forced into an authorized representative assumption of liability model.
So I agree with you to a certain point. I think for those individuals, and I think that there's a line there, for companies that think that they're going to be, summer interns are a great example, and we've spoken to, the government individuals offline on this. If you're not sure, if you think they're still going to come in, like you're hoping that they're going to get 2 weeks in at the end of the office, they get to see your operations, so you can convince them to come work for you after they graduate. I think, and it doesn't work out, I think you're going to be able to document. But if you're starting your program and you're saying it's going to be 100% virtual, I think that's a different story. And I think it's going to be hard not to, to be able to say that you should have done something else at that point. But again, with your first example, I agree with you as well. If people just never end up, coming back, then you just continue to document and normal operations never resume. I mean, I think that is going to be the reality. We are already talking with companies that are saying, you know what, we're not sure. Maybe we're going to continue to work from home, at least for the next 6 to 12 months. So it is important to just to kind of to know. Leon, anything on that before we go back up? All right, and we are getting questions on once we open back up, when we verify the documents physically, we can't tell the employee to bring in the same documents that we inspected. I got that a couple times, and that is correct. The employee, as Angela said, the employee has their choice of documents. They may bring in something else. Let's take a look at some of the other Q&A examples. Go to the next slide. The next slide. Okay, great. So, one of the things when we were trying to get ICE, the bottom line is we were trying to get ICE to remove the requirement to have that second look in person, but they didn't buy it. They basically said, no, you're going to have to look at them once you come back. We'll talk about some of the advocacy afterwards on having remote as changing the regulations. But for right now, you are responsible for completing the I-9s. So what happens when you're bringing back a large group? And we did try to explain that to the government, because they said, well, how many people are you hiring? And we said, for some of our companies, they're hiring a lot, or it's adding up. Maybe it's 30, maybe it's 300, maybe it's 3,000, maybe it's over 100,000. It's a lot. So for those HRs, we've explained, HR managers, they generally don't want large groups of people, traced into their office and, handing them dirty documents. And I think I've talked about this, taking down their mask, and, it's an issue, and it's something that, again, we're going to have to redefine this new normal. But for now, we're stuck with the guidance. So you're going to have to come up with some process. If you don't want to go authorized rep, you're going to have these people come in. You want to think about it, HRs, or especially where you don't have professional HRs. I mean, that's generally the problem. Professional HRs generally will think about these types of things, but if you have, just shift managers or others completing, they may be putting themselves into danger and not even, realizing that. So you can still have somebody, standing 6 feet from you. Maybe you're doing it in a large room. Maybe you're even doing it outside, have the hand sanitizer there if you're looking at documents. It's not an optimal situation. I mean, we know it. We keep communicating it to the government. In terms of other,
I'm envisioning sort of what they do with drive-through testing these days.
There you go.
You drive through, present your documents from a distance, and then drive away. And
what about the window? I like that. You can keep your window up. You can take your mask down. I really like that. I'm totally serious. For employers that have several hundred, maybe you do an outside, especially if you have groups coming back. I mean, it's not funny, but you have to think about these creative things, and that's going to be something that it is going to be important. I really like that, Angela. You're going to have to outline that more. So in terms of tracking, a lot of our companies are saying we don't know when people are coming back. In my office, I don't know if I may go in. That doesn't mean that we're open. And you are going to have to come up. Somebody has to own it. That's what I keep telling our companies. Somebody, some group, somebody has to own it. When are people physically coming in? There has to be a way to track it. And if, individuals come back later on, use that additional information box. I know it's small. Make sure you have an electronic vendor that allows you to type into it and put down, this person didn't come back until January. You don't have to put all their, health information. You don't have to put whatever's in their personnel files, but you can just say they did not physically come back until X, Y, and Z. So have a system, and if you do have an electronic system, make sure you have one that works. Next slide, I want to go through. I don't want to get caught short with time on the illustrations. Next slide, please. No, next slide. Okay, thank you. So this one here is completing the Section 2 when you're inspecting the documents. So this is their first example. You can take a look and you look at what's in the what's in the additional information box, and it says remote inspection, and it tells you the date that it's completed. So this is basically this is the initial. This is how it was done initially. This is a suggestion. And by the way, if you've done it a little bit differently, especially for the return to work, I mean the initial ICE and CIS did give guidance. But when you start seeing these other slides and you already have people that have returned to work, it's okay. These are suggestions. Doesn't mean it has to be done exactly. This is not, a mandate. But if you're missing something huge, change it going forward. Okay, just make sure now that these documents have come out, and by the way, share them. Those of you that are in organizations, share them, because I don't think that the government has done as good a job as they could have getting this information out to employers. So it's our
Dawn, just 2 quick points
Sure.
in passing. It might help because of the size of the text is so small that you read those when you illustrate each one. But the irony to me is that the government has in their example put NA, NA, NA in all of the boxes that others might leave as blank. And is that a new standard? We've seen that in the immigration world where things are rejected because NA is missing. And
so this is Angela. This is what happens when you use the form fillable one. Where actually whatever you don't fill out, it fills out for you. So once you select list B, this is the free PDF. I forgot what it's called. It's like the form fillable one that you can use on their website. That has some smart error detection and omission technology in it.
I'm just suggesting that this should not be the basis to establish a new standard of how to complete the form.
That's a great point. Please don't be putting NAs in there, exactly, unless you're using the form. That's a great call out. All right, we're going to go to the next slide, and we're going to look at performing the physical inspection once the normal operations begin. So in this instance, this person, it's the same person who did, if you're a small organization, you have one HR, I have a lot of companies, I was surprised that, they're doing the physical and they're going to be the ones responsible when the person comes back. So in this case, you'll see the red circle, basically, Angelo did the I-9, and now he's making the notation in script, COVID-19 documents physically examined on, he's putting the day, and then he's putting his initials, and in this case, obviously it was Abigail Adams, AA, not Angelo Paparelli, AP, and that's it. It's simple. It's a basic one. That's all they're asking for. So that is the same person. But in real life, there are many, many situations where that's not what happens. So next slide. Okay, so this is going to be more common. All right, so it's the physical, the physical completion is being done by somebody else. Okay, and in this case, you'll see it's they want the person's name, they want the full name and the title of the person that's actually going to be completing it. Now, I found this curious. I thought that it was a different completer. I thought, not only that, I heard them in different discussions. They had said, well, they still want, the person who actually sees the documents, if they were different, if it was different than the person, if they're different documents, they want that person to actually sign under penalty of perjury. But when this guidance came out, it doesn't say that. I know that many not many, but some of the better electronic I-9 systems, when you are going in and you're signing this, there's actually like something that you're signing, basically saying you're doing this under penalty of perjury. I don't think it's a bad idea. Some companies want to see this. They want the person who's doing this to know that they are looking at these documents. These are, larger organizations or organizations that, they're concerned with potential fraud, even by those that are completing the I-9. So in that case, if your electronic I-9 doesn't help you with this, another thing to do, I've seen other companies do it exactly like this, and then also sign off on it in Section 2, put their name in Section 2 as well. So that's a possibility that you might want to also, and I don't know if you can see my mouse, but where Abigail Adams is signing right there under her name, where you may also want to have the new Betty actually sign her name down there. It's not necessary, and look, if you want to just do the bare minimum, what I was asking, I think you're totally fine on that. Okay, so let's go to the next slide. All right, did someone else, Angela, you wanna talk about this, notating the remote physical inspection?
Sure, and this involves, again, using the special dispensation of virtual completion on a given date, and then demonstrating the date of physical examination on a different date with a different person, if I'm reading this correctly, than was before in a reverification Section 3 context.
Sorry, I was on mute there. Yeah, so this in this particular case, this is the notation of the remote and the notation of the remote and the physical inspection for reverification. You can see, and I'm sorry the slides are so small. I thought that they would get larger. You can see that the individual that's signed, they're putting the date that it was completed. And then they're also putting the date that the physical inspection was completed. All right, we're going to do the next slide. Yeah. Oh, and by the way, on that one, I should have on the slide before. I want to point out it's sometimes confusing that was a Section 3. But Kelly, can you go back a slide? I may not have been clear on that. I should have, okay. So if you notice here, I see there's an arrow missing. So the arrow in the middle of the additional information, that basically refers to the information that's actually completed in Section 3. Okay, so that's where they're saying you can still use the additional information box that is physically located in the real estate of Section 2, but you can still use it for information that you're putting in Section 3. So I just wanted to, to clarify that. All right, next slide. Okay, so electronic I-9s, we've already really, we've talked a lot about this, and I'm not going to go over it too much. Look, at the end of the day, if your electronic I-9 system is not already thinking about this, they should be, and you should be asking questions. Like, don't wait for your company, for your employees to come back to work to figure out what your electronic I-9 can and can't do. So some of them are already rolling things out. Everything's already working. A lot of the other ones are thinking about it, and then others are basically saying, like, we're not going to be able to do anything for you. You're going to have to do an entirely new I-9. So I think a lot of things are coming out. A lot of companies are realizing the limitations outside of COVID, like where you can't make a change to Section 1 or Section 2 once the employee completes it. I mean, that's like, yeah, that's not a good system. So something to think about. All right, next slide. Would we keep going? Did that one already? Next slide. Next slide. All right, great. So, Leon, quickly, I know for many of you, you heard our webinar on Friday, but look, this is where things are going. I mean, immigration compliance, not just I-9, but H-1Bs and all over, it's not going away. You want to give us a quick overview and update on what we can expect?
Yeah, so what we can expect is that in some critical respects, the overall environment for immigration compliance has not actually changed, notwithstanding all the flexibility we talked about for the last 50 minutes. And so there is all kinds of enforcement action going on in various agencies at various levels of government, all of it based on a prevailing view of policymakers that, in fact, there is rampant fraud throughout the immigration on immigration compliance issues, and frequently that fraud is to the disadvantage of eligible U.S. workers, and so that's why you have the Department of Justice Immigrant and Employee Rights section enforcing the Buy American, Hire American executive order from 2017. Looking at cases where there is discrimination in favor of foreign national and against U.S. workers. You have more Department of Labor investigations focusing on various labor certification compliance issues. And you have coordination among all the agencies, Homeland Security, Department of Justice, Department of Labor, all looking at these issues pretty aggressively. I don't remember.
And Leon, I think it's good to note at this point, sorry to interrupt, but that all of these agencies behind the scenes have intersecting memoranda of understanding, where if one agency finds something that looks to be a violation in the bailiwick of another agency, they forward it on. And so this will have the tendency to replicate the number of investigations by all of the agencies.
Yeah, and along those same lines, it's not only the referrals, there's also joint task force, right? And Leon, you know, when you're at the service, I mean, I think more and more we're starting to see agencies working behind the scenes and referrals. And you know what? The other thing that I'll say here is, when something is, in vogue and it's hot and it's sexy and everyone in the government, when something's seen as of interest, the agents and the auditors and the adjudicators, they tend to focus on it more. And I think that, at the end of the day, especially on, we've seen where there are I-9 investigations and E-Verify investigations that are intertwined with the H-1B investigations, and I think the proclamation that we just saw is an indicator what's going to happen, and especially with the DOL. I don't know if either one of you want to comment a little bit more on that.
Yeah, I mean, the one thing I wanted to, and forgive me if we said this early on, but back in March when we did get that big round of notices of inspection, that was one of that may have been the very largest sort of patch of notices of inspection that we've seen during this presidential administration, which already has served more of these than anybody had in a very, very long time. And so, I mean, I think it just underscores the overall commitment to this area, the overall assumption that there are problems out there, I think is all underscored by that. And to the extent that they're sharing information among each other, that just raises the stakes internally just that much more to actually get a result that makes that investment of time and coordination worth it for the agencies.
Leon, you're a pretty astute observer of the political scene. What happens if we get a different administration in January? I think things are slow to change. Between administrations, a lot of that's going to depend on what the priorities are of the new administration. I would tend to doubt that easing I-9 requirements will be the first priority for a new administration. I think they're going to be focused on, even if we're talking on the topic of immigration, I think they're still going to be focused on other things than, making life easier for employers that need to fill out I-9s. And even if there was a general liberalization of the immigration landscape, it would probably not be politically realistic to expect that would be coupled with an announcement that we're going to go easy on I-9s.
No, I don't think that there's ever going to be an easy on I-9s. I think what we see is kind of the back and forth. Are we targeting employers? Are we rounding up the employees along with the employers that we're targeting? So in other words, are we taking people into custody? Like that's kind of where before COVID happened, I saw two things that were coming down the pike. I saw more interest in picking up the employees, and I also saw a renewed interest in what we call the blackies warrants, where ICE could come in and actually physically pick up individuals without knowing specifically who they were. Blackies was a steakhouse actually in Washington, D.C., and this is a really old case that allowed ICE to do that. And my understanding was that they were starting to go after employers that had large contingencies of unlawful workers on their sites. So we saw that. We also started to see many of the special agent in charge offices across the country starting to not issue just one notice. So if you had, let's say, especially in hospitality, if you had a group of restaurants and you had, 10 restaurants in Chicago, used to be you would get just one of them, but no, they were hitting all 10. They were saying, they were issuing separate notices of inspection for that. The other thing we saw, and I don't think will go away even with the change, was an increased focus on electronic I-9s and on the systems from ICE, and then also a growing interest, although there definitely was already interest from the Department of Justice in the Immigrant Employee Rights Group. Just this morning, as part of an IER query, a charge, the IER Justice Attorney actually asked they want to demo the system. They checked around and didn't really know the system, and decided that could be a good thing, that it didn't have a reputation in the office, but they wanted to demo the system. So now is the time. I don't think it's going away. I think that as you found problems that were cropping up, you should start making your list and being able to prioritize. I fully understand. I mean, I'm on the phone, with employers, and we're going through something, and I'm thinking, and I want to tell them, your electronic I-9 system is a disaster. You've done everything wrong. Probably all your I-9s are going to be considered not completed. But, this is the same HR that is dealing with 67 COVID cases, and I can't even say it. I can't bring myself to say, oh, we're going to talk about electronic I-9s. I mean, the reality is that there are certain other priorities. But that said, make yourself a list, and when we return to work and return to a new normal, start to chip away and start to address. So I think let's go on and talk about the our last issue in advocacy, and then we'll take your questions. Next slide, please, or 2 slides. Policy advocacy. So I'm going to kick this off, and then I'd love to hear from my partners. I have been, trying to push the allowing for virtual I-9s for a really long time. And I've come up with every argument. We have telemedicine now. There's, everybody used to be insurance companies wouldn't pay for telemedicine. Now it's becoming common. What's the difference between, or what's the definition of physical inspection? The regulation says that the documents need to be physically inspected. They don't say in person. USCIS decided in person. And when I sit and I talk to the ICE agents and they say, oh, we're never going to give up on this. For fraud, we have to see the documents. When the regulations were written so many years ago, we didn't have, we weren't doing Zoom, right? We weren't doing this WebEx where you can see me and you can see me in my home office, and I can hold up my, my phone, and you can probably, see my kids, and you can read documents. That's not what it was. I mean, the regulations still talk about microfiche, right? So we are so far from when the regs were written. We need a change, and there's so many of you out there that are asking for a change. So we're working with many of you. We are working to, we're doing kind of a double punch. We're hitting the agency, at the highest levels. We're also working with the department. We're working on, different kind of ideas and, potential pilots, and then we're also talking about a regulatory change. So, Angela, why don't you start that off and give us your
Sure.
Leon can tell us.
Sure. I think what we should also note is that Leon co-chairs our government relations and policy advocacy team with Randy Johnson, the former vice president of the U.S. Chamber of Commerce, and the two of them are able to help form alliances, not merely to change rules, but to change statutes. And perhaps we will never hear a voice of reason coming from the enforcement agencies, because they're concerned about fraud more so than about feasibility of compliance and ease of compliance. And so that's my initial comment, is that we cannot just sit back and importune the agencies to be reasonable when the history tells us that they have been reluctant to be reasonable.
Agreed.
Yeah. So if I can add, I mean, I think we are at a moment right now where the environment is really ripe to push on this issue. One, because everybody's now gotten used to using remote verification. A lot of companies like it and don't necessarily want to go back to the paper environment. But the practical reality is that ICE's concerns about fraud, and I'm a former prosecutor, and I'm a former fraud prosecutor, so let me just put that stronger point on it. They're misplaced. One of you had asked, well, why? And the reason really is not just ICE, it's the Department of Justice. And the Department of Justice to this very day believes that if you're prosecuting a case of fraud against the government, the only way that you can win that case is if the document has a wet signature from the defendant on the document. Now, this is in a day and age when, for example, this afternoon when I get off this call, when I get my insurance reimbursement checks from my health insurance, I can deposit them online with my phone. In other words, the banking system trusts remote technology enough to, on a broad scale, allow remote transactions. So the pure fact is that neither ICE nor their lawyers over the Department of Justice are getting where the world is technologically. And they need to be shaken into that understanding. We have the level of telephone, smartphone resolution that you need in order to capture these documents. In a lot of ways, it's actually better. If you make a color image of a document with a phone, that is better than me with my 58-year-old eyes looking at documents that I've never seen before, and then doing a smudgy black and white copy of those documents. And so these are points that need to be urged on the Department of Homeland Security, on the Department of Justice, and to make clear what the costs are to businesses and the lost compliance opportunities as a result of it. And so what we see going on, I mean, Angela mentioned our government relations work, is what we see going on is companies really now wanting to move into an advocacy mode on this, to form coalitions with other companies. And so that is something we wanted to share with this group today, because I think there are going to be opportunities for all of you, to the extent that you want, to really join in to push at various levels of government, including up in Congress, but also at the bureaucracy level, to really bring us toward a more rational system of how this is conducted. By the way, without sacrificing anything as far as preventing unauthorized work in the United States.
And just to add what you said, Leon, not only can you have greater resolution taken from a smartphone than a document captured and saved in microfiche, obviously, but the prosecutors are wrong because they have wire fraud authority. And so they already have the criminal enforcement mechanism whereby they don't need to prove fraud only by a wet ink signature, but they have multiple other ways to prove that something has happened illegally.
Yeah, and in fairness, it's so funny because I love to complain about the government, but I also, want to be transparent in what we know. Look, they're working on things, right? I think there's probably a little bit of a disconnect between Immigration and Customs Enforcement and USCIS, the verification division that houses E-Verify. I know that there is interest on both sides in kind of moving along from a technological perspective. And, there's been discussions of, facial recognition technology and matching up documents and, but things have been slow. I mean, if you look right now, there's only a limited number of Department of Motor Vehicles that participate in the USCIS E-Verify Ride program, which doesn't match which matches information, not necessarily the photo in E-Verify. So, there's a lot of limitations that are on these programs, but I do think that they're moving in the right direction, and we'll start to see, hopefully some more pilots as the return to work redefines normal, because that's what's happening, and the government's going to have to get with it, but hopefully, alongside many of our clients, we can push this through and we can bring innovation and we can bring ideas. It's not just the virtual. How many of you have I spoken to with digital signatures? Like, why can, for companies that want to, to send the I-9 for someone to type it in, why can't we use, DocuSign or other things? Why can you sign your tax returns digitally, but you cannot sign an I-9? There has to be off-the-shelf systems that are not that expensive that can be used in lieu of electronic I-9s. So there's the electronic signatures that's an issue along with the documents. So look, the point and why we spend so much time on this is because we're moving it forward, but we need your help. We need your examples, and we need you to join forces so that we can continue this conversation both on the Hill as well as with the agencies. So we're going to move to questions right now. So we're going to try to go back and answer some of the ones that already came in, but we're also going to ask you to type in your question. So I'll start off, and I'm going to go back to some of the earlier ones. There were some comments on, remote work not going away, and whether or not DHS has indicated any plans to redo their process since it seems out of date. No, they're not going to redo their process. They've already told us that. We may get some clarifications on this, but I think this process is here to stay. And then I'll take one more, and I'll then start throwing them out. There was another question about the authorized representative, and people were wondering, how you could, go use a notary or third party. Frankly, right now, we're not really talking about notaries. We're talking about what we're calling this friends and family model, where, people, neighbors, people that you're actually, you're in your social distancing circle or whatever you want to call it, that's who, are doing these I-9s, not notaries. And on the notary note, I would say be careful, because there are some states that don't allow, including California and Texas, that don't allow for a notary to complete the I-9. And the other kind of, urban myth here with that is that, notaries have no special expertise. There's no reason. They don't need to stamp an I-9. They don't know it, any more than, maybe, Leon's wife knows how to complete an I-9. I'm thinking, she probably knows how to correct one. Well, my kids certainly know how to complete I-9s now, better than notaries. So, yeah, you need to be careful about that. All right, do you want to read your questions, or do you want me to throw them out to you? I'll let you.
Dawn, I'm not seeing the questions, so if you want to throw one at me, that's fine.
Okay, great. So what do you do? We kind of answered this, but what do you do if you have a few employees reporting to the worksite for essential operations but are otherwise completely remote?
I think what you do is create a record of your circumstances as best you can to document why what you did was consistent with the resumption of normal operations, and hope for the best.
Okay, fair enough. And I do think, again, you may have people that we were totally remote, but I went in a couple days. I don't think that kicks us out of being able to use, virtual for anybody that we were onboarding if we were still onboarding. All right, so again, let's see. Do we anticipate the remote option being taken away before the distribution of an effective vaccine? Leon, what do you think about that? Whether or not they're going to extend it past July 18th? Because I don't think
I don't think we know. I think that they've been moving as slowly as they could, giving these 30-day extensions. This most recent one seemed to want to put a sharper point on the idea of 100% of people at the workplace. So I don't think we can count on there being continued flexibility right up until the time that there's a vaccine. Also in the context there are places, there's a lot of variety around the country as to sort of levels of reopening, and that's, I think, influencing how the department is thinking about these issues.
So there's a question: would the state stay-at-home orders count when they were in effect? And I think that was referring to some of the telecommuting or work-from-home policies. Maybe the person's asking about whether or not they would count. And maybe if your company didn't say something, they didn't send you, but you knew you were, in San Francisco, you weren't able to, to go out, or New York, or whatever it is. I think you could probably use those. Anybody disagree?
I enthusiastically agree, and I think to the extent that they're not honored by ICE, I think they're going to have quite a fight on their hands, because I think that's affecting people's ability to actually get to the workplace. I think they're trying to follow what their local governments are telling them.
Yeah, I agree. And I'm seeing questions on is how employers handle being out of sync with the 100% remote requirement. Look, at the end of the day, I think that if you did it wrong, in March, April, May, even June, right? You did it wrong. Do it right now. Get your, as your people are coming back in or they're already there, get your I-9s done, document your policy, and that's it, and just move forward. Because I think at the end of the day, I think ICE is going to be reasonable. And somebody asked a question of, well, maybe they're going to be reasonable in the next 1 to 2 years, but what about 10 or 20 years from now when we're audited? And I will say, if Hurricane Katrina or any of the other natural disasters where individuals had late I-9s or lost I-9s, we've done several audits, a large number of audits, I think, relatively speaking, where we've had issues like that. And I've never had an agent not respect the situation as it was at the time. And if I did have a cowboy or a cowgirl at any point, I just went over and went up the chain until we said, this is the situation. And then all of a sudden, reasonableness prevailed. So
I would put a footnote in it, and there's actually a new hire opportunity, and that is COVID-19 I-9 archivists need to be hired by employers in order to make the record that will persuade the person not to be a cowboy or cowgirl.
Is that going to be your business when you retire?
No, I'm not retiring. I've got a lot of fight left in me.
I was going to say, don't go anywhere, Angela. Yeah, I think, look, companies should just do their best. All right, when does that 90-day clock kick off? Upon receipt of the document. So, Angela, I think that they're talking about having the receipt. I think they're talking about with the List B documents, if somebody put in somebody presented a receipt from a Department of Motor Vehicles or a government agency that was not extending, and I think that's what they're asking upon receipt, or maybe they're even asking in general.
I'm going to confess ignorance and throw it back to you. That's too complicated for me.
No, so it's not upon receipt of the document. That was the question. It's 90 days from actually presenting the document. So it's not 90 days when the person gets it. So you're going to have to track those, and hopefully you already have some sort of tickler system. If you're paper-based and you don't have a tickler system for tracking your reverifications in general, people that have expiring work authorization or receipts, you should have one. We recommend putting them in if you're paper, in a binder system where you have those I-9s that need reverification in reverse date order. People that are coming up for July 1st, they would be, at the top of the pile, and you keep going down. And for those of you that use an electronic I-9 system, if you're not getting reports and you don't have a dashboard that shows you when your receipts are going to expire, including now these COVID ones, get a new electronic I-9 system because you have to have a dashboard and you've got to have reports. It's just a mess if you don't. All right, so we already answered, can someone present documents that were different than presented in the original virtual inspection? The answer is yes. I'm not sure if you covered this, I got on late, but are we required to re-inspect the documents for employees whose information we reviewed virtually to re-inspect within 3 days of opening the office or within 3 days of the individual's return? So, at the end of the day, this is kind of the crux of the issue, right, that we've been kind of going back and forth on. When does that 3 days start? And I think the government has indicated that they're going to be reasonable, and I think it's going to be within 3 days of the individual's return, and you're going to track. I mean, I think the government does not think that every single person is coming back on a different schedule. So you're going to have groups that are going to be returning, and somehow you're going to have to document, I think, in that additional information box if somebody's outside. Angela, anything else on that?
Well, I also think it may involve recording the reason why the person is returning later than a group.
Yeah, and I wanted to talk with our partners in the other areas, and Leon, even you do the healthcare work. I mean, I think you need to be careful. Like if you're going to they have some sort of accommodation, you certainly don't want to put any of their medical information. I had seen an I-9 where somebody put, the person's immunocompromised, and they're not going to be coming back. I would not recommend, even without asking our partners, putting all that personal information on there. Does everyone agree?
Well, I think a statement that is not particularly descriptive, that basically says there are legitimate business reasons for this person to come later, and then fight it out later if and when.
That's right, and that's when you would go back to the file, and you'd be able to say there's an accommodation in place, and then, I think, now that said, if, 75% of your workforce happens to have all these, unknown accommodations, they may certainly ask about that. But Leon, anything on that?
Yeah, no, that you took the words out of my mouth. I think I think you can survive sort of a handful of sort of isolated cases where there was some reason why a particular person was late, but it's going to stop being credible at a certain point, and it's going to cause you a bigger problem than just sort of admitting you just didn't do it on time.
Yeah, okay. These are some other really good questions. We've started rehiring staff on site. I am on site as well. Do we need to review all docs again if they were just employed 3 months ago? If so, is this necessary for all employees or just non-U.S. citizens? So I think this question refers to somebody that may have been furloughed or terminated and now they're coming back. So that, I would say, you would go back to your rehire policy. Some companies allow for you to use Section 3. As long as the I-9 Section 1 was completed within the past 3 years, you can use the same I-9, and you can actually just complete a Section 3. Whether or not you have to look at documents depends upon whether or not the work authorization is still valid. Whatever you do, the second half of the question, for non-citizens, you want to have the same policy in place for U.S. citizens or all U.S. persons, permanent residents, asylees, refugees. It should be the same policy. Not to get too down in the weeds, U.S. citizens will not have to have their work authorization re-verified, though. So this is really a re-verification question. Go back to your policies on that. And then another really good question is, I know with the paper version that the regulations state that everyone is supposed to physically sign the document. What happens if someone doesn't have or have access to a printer to do this? And we had that for many of our companies, especially those that were doing the authorized reps. So we had some HRs that were doing the virtuals, and they didn't have printers. So we literally, told our companies, Amazon, it'll deliver the printer. They're very cheap. Send that over. So, make sure that your HR manager, whoever's completing I-9s, has a printer and has the ink. And then for those employees that needed to sign or print out for authorized rep, we actually FedExed. And early on, my office actually sent FedExes out to some of the employees on behalf of our companies. So, there are creative ways to get around these things. And if you use the authorized representative, should we still examine the new same documents upon the office? So the answer is no. You don't have to have that second step. However, what I did say is that you have to have an audit process in place. And Angelo spoke about some of the issues that we see with authorized rep. So there's no requirement to relook at those documents or you to see the originals ever, but it is incumbent upon, I think, companies to make sure that who's ever doing the authorized rep is doing it right. I mean, oftentimes we see the wrong documents selected. When you look at the actual document, you see what was recorded. They're entirely different. So, Angela, I'll ask you, what's your perspective on using an authorized agent to complete the in-person verification?
Well, it carries with it the same risk of using an authorized agent for the initial completion in the sense that there may or may not be competence on the part of that person and familiarity with the regulations. But in addition to it, it also raises the question of how does this interact with the concept of resumption of normal operations? Is it an exception to normal operations that you're doing this, or is it an accommodation of some sort because of geographic distance? I think it's going to be a fact and circumstances situation, but I don't have philosophically an objection to using a well-trained authorized rep for completion and updating of the virtually completed I-9.
Yeah, I would be careful about using the authorized rep to complete. I don't think it was intended to. I don't think that ICE intended to use the authorized rep to have somebody else do those. I guess it's possible. I'm not going to say no. I'd have to think about that. But I would be really careful, and I'd really want to walk through all that before we would allow for anything like that. Kelly, can you announce the CLE code, please?
Absolutely, Dawn. So the CLE code is SS, as in Seyfarth Shaw, 0391. SS 0391.
Thank you.
Back to you, Dawn.
Perfect. All right. Let's see, the virtual exception only applies to employers or workplaces that are operating remotely. And if there are employees physically present at a work location, we're getting questions so quickly it just bounced it off. If there are employees physically present at a work location, it doesn't apply. Have we received any specifics what a work location entails? So no, ICE hasn't said that, but I would think that reasonably, in light of how they look at notices of inspection or anything else, it would be a physical site. So if you have people on that physical site, I think. Any disagreements, Leon or Angelo?
No.
I think you're right.
Okay. A lot of our new hires are not remote, but all of HR will remain indefinitely. We use electronic I-9s, and we do not allow access to the system to anyone but HR. We've used the remote process for all new hires. Can we defend this? A lot of our new hires are not remote. Yeah, I don't see how you're going to defend that. I think you're going to have to talk to your electronic I-9. I mean, I don't know the specifics. I don't know when you say a lot. If you have a lot of people on site, then I think you have to use the I-9. You have to complete the I-9. Now, a lot of the vendors, this is a great example of a vendor limitation. Many of the vendors have the authority or the ability for a third party, like a notary or a friend or family, to complete the I-9 just for me, just my I-9, not to get into the system or anything like that. And I think, that's what you should be looking for. If your system isn't allowing it, if you physically have to get into the system, then that's a system limitation. That's not going to be ICE's problem. ICE is going to look at it and say, we don't really care if that was a problem with your I-9. So you could have had somebody else. Or the other issue that you could do, the other workaround, is to use a paper I-9, and then to have those paper I-9s digitized and put into your system. So I think we're 2 minutes over. Angelo, anything quickly to end up on?
I want to just thank the audience for their patience with this complex and frustrating subject, and hopefully we'll get clarification from the government in some fashion.
Leon?
Couldn't have said it better. It was nice spending a couple hours with everybody.
Exactly. Okay, very good. I hope everybody has a terrific week, and I hope things get easier. Stay safe. Take care. Bye-bye.
This concludes today's webinar. Thank you for attending.
Okay. Guys, I have a 2:30, so